Welcome back to the Emily Show, and as this episode drops, you're probably anxiously updating your Law & Order app to see if there is any movement in the Karen Read trial. I know that the jury is out deliberating. We are waiting for a verdict. Will they have a verdict Monday, Tuesday, Wednesday? I don't know. I sure hope that they do. It would be really nice to, after 2 trials, know what a jury thinks in this case. And as we are waiting for a verdict, I've talked about on the live channel at the Emily D. Baker, all about the counts, the jury instructions. That was all on Friday's stream and in the case briefs on this channel, The Emily Show. So if you want to know what all the charges are, what the lesser includeds are, why the jury has to decide 3 different charges and then like 4 lesser includeds, it's all there for you, because today we're going to talk about other things. Don't worry, I'm sure we're going to talk more about Karen Read. Some of you are just fatigued and are like, Emily, there are other things going on. I know. And right now we're going to talk about them because there was a new hearing for Donna Adelson in Florida. And shockingly, Donna's not happy again. She wants a change of venue. We're going to talk about it. We're also going to talk about Kouri Richins, whose case now has a trial date. And there was a lot of new information in the hearing I attended for that case. And we have to talk about what's going on in the Kouri Richins case. And of course, there was a massive dismissal in the Blake Lively-Justin Baldoni case. And we're going to talk about what the court ruled, what it means, what it doesn't mean, and where that case goes from here. So stick around. We've got lots of cases to talk about. It's the Emily Show. We should just get into it. I'm legal analyst Emily D. Baker. Yes, also a lawyer. And this is the Emily Show. I break down the pop culture, entertainment, and high-profile cases that we're all talking about. I know you want the facts, so let's get into it. And yes, as I said, all of you are updating your Law & Order app. If you don't have the Law & Order app and you're like, Emily, what is this thing that you are talking about? It is free in the iOS store and in the Android App Store, Google App Store, and all of the app stores. And I will send you push notifications when something happens in court. Right now we're on verdict watch. So if I am going live because we hear that the jury is coming back in for a question, or we hear that something is happening with a verdict, I will let you know. You will get a push notification, so you are not sitting there refreshing all of the feeds all day long. I will do that for you. I'm going to be doing it anyway. I'll just send you a notification. And if you already have the app, you got a notification about this episode this morning, and now you know it's working. Let's go. We need to first go to Florida, though. So let's go to Florida and talk about Donna Adelson. You might remember the name of the defendant. You might remember the case. This is a conspiracy to commit murder case. Her son was tried several years ago now. Her trial was supposed to start last September. And then at the last minute, there was an attorney conflict, which the judge had asked all the attorneys about 1 million times. And all the attorneys were like, it's good. Until it wasn't. She was supposed to go to trial in June, and that trial date was delayed until August 19th, 2025. Donna Adelson's newest set of lawyers filed a motion for change of venue back in January of this year, and it had not been heard by the court yet. So on Friday, they had about a 3-hour hearing with one of the experts that you've heard on media and media velocity and some of the other cases where we've seen change of venue motions. Emily, is today a day for change of venue motions? Yeah, we're going to talk about Kouri Richins' change of venue in just a minute, but Donna Adelson would like to move her case out of Tallahassee, Florida, to elsewhere in Florida, saying that this case has garnered too much attention. And the prosecution in that case said, look, we've picked juries in multiple cases connected with this because there have been multiple convictions in this case already. And the prosecution said to the court, this isn't any different. People aren't more specifically interested in Donna Adelson than they were in Charlie Adelson or some of the other already convicted co-conspirators. And they said, yes, there is some volume in this case, but it's not more than we would expect. And we should be allowed to start picking a jury and see if we can find jurors. We shouldn't have to move venue. We have not had a problem with it in the past. And Donna Adelson's team said, look, there is a largely negative sentiment about Donna Adelson on podcasts and a court transcript that was supposed to be sealed regarding Charlie Adelson had gotten unsealed by accident, and the media had gotten a hold of that. And now there is things in the media that are possibly and likely not evidence in the case. Okay, that happens in just about every case that we have seen. And sometimes it's not even things that comes from a court file. It's just things that aren't true that just go running wild on the internet. But the fact remains that there will be a percentage of the population that just doesn't care, that hasn't heard about this case, that doesn't care about it locally. And the distance in time from this prosecution and the crime itself is so great now that there is a better likelihood of people having more distance from it because the crime took place so long ago. The murder of Dan Markel took place on July 18th, 2014. So we are now more than 10 years out from when this murder happened. So even though people in the area might remember it, and might have been connected to it, the longer time goes on, the more distance there is from that. And I think the reason people are familiar with Donna Adelson is, one, her son was convicted, I think in 2023. Two, she was arrested at Miami International Airport trying to, well, the prosecution alleges she was trying to flee the country. The defense says she was just on a one-way ticket to vacation to a non-extradition country, and that should there have been a warrant for her arrest, she would have come back voluntarily. She didn't want to come back in handcuffs. I think really what her lawyers didn't want to say in court is that she didn't want to have to fly back coach and get fed a ham sandwich by like Homeland Security. She'd rather book her own first class ticket because she would like to be more comfortable on her flight. That's generally the impression they gave at the hearing I covered when they were talking about this not being fleeing to another country. It was just a vacation, and she was totally willing to come back. She just didn't want to be arrested in another country because that would be unpleasant. But if you haven't watched that hearing, I will link it down below. So Donna Adelson's trial date is now set for August. It looks like it might overlap with the beginning of the Kohberger prosecution, but we will see. Every time Donna Adelson's case seems to be set for trial, something happens and it gets bumped back. The court, to me, did not seem inclined to grant the change of venue. The court reserved the ruling. It seems that the prosecution's arguments that they have been able to pick jurors repeatedly might work, but the judge might also reserve ruling and say, look, we should start jury selection. And if we get back a large selection of jury questionnaires that say people know a lot about the case and have made up their mind about the case, then maybe we reconsider this after jury selection has begun. We will see. Donna Adelson has also made a motion to get rid of this judge that was denied. She asked the judge to recuse himself. That was denied. So we're seeing some of these pretrial motions get started. There will be another pretrial conference in August. I will keep you posted on what's going on with that case. And if it goes on during Kohberger, maybe we will go back and cover it live. It should be about a 2 or 3 week case, if that. So maybe we'll go back and cover it live even after the fact. But that is what's going on with Donna Adelson in Florida. I was really hoping that trial wouldn't go at the exact same time as Kohberger, but the Kohberger case is going to take from mid-August through at least mid-November. So it's going to cover the rest of the year, basically. And speaking of motions for change of venue, we need to talk about Kouri Richins in Utah. We watched the last couple of Kouri Richins hearings together on delay because the court very much does not like streaming, does not want the case streamed, and is not a huge fan of the media coverage of the Kouri Richins case. Kouri Richins is the Utah mom accused of poisoning her husband. After her husband passed away, she wrote a children's book about grief and was promoting that book on a little bit of a local book tour when she was arrested for his murder. Her arrest came about a year after he died. A lot of that was because they waited to crack her phone, and in the things they found in her phone were Google searches like luxury prisons for rich people, and what does the coroner's report say if someone dies from fentanyl overdose? Things like that. She also wrote that walk the dog letter that you might have heard about in court because, well,
DOCKET 214, but every law nerd on the internet calls it the walk the dog letter.
Every law nerd on the internet does in fact call it the walk the dog letter, Mr. Bloodworth, because the letter at the top says walk the dog, and then goes through and tells her side of the story of what she wants her mom and brother to testify to in court. So the walk the dog letter, that's all the Kouri Richins case. She had made a motion for change of venue, saying that in Summit County, Utah, everyone just knows the Richins family. Everyone knows her. They know her husband. He had a local business. She can't get a fair trial there. She wanted to be in Salt Lake County, Utah, which close enough. There had been discussion about whether jurors would come up from Salt Lake County, Utah to Summit County to the courthouse where the Gwyneth Paltrow trial had happened. So the change of venue motion was denied. Kouri Richins' team took an interlocutory appeal. That is an appeal that goes on while the case is pending, not after the case is done. Normally a case is concluded and then there's an appeal on an issue. This is an appeal that happens while the case is moving forward. So Kouri Richins' attorneys said, we want to take an appeal on this. We would like the court to allow us to take an interlocutory appeal. And so her criminal proceedings were stayed when they took that appeal. Well, on June 9th, the Supreme Court of Utah said that this was not a matter they were taking up on interlocutory appeal. They didn't rule on the merits of the case. They said procedurally, this is not a case that we are taking up this way. So no, we are not going to take it on appeal. So on June 13th, all the lawyers were back on their Zoom meeting for a hearing and to lift the stay. The prosecutors asked to lift the stay on the case and said the appeal's not moving forward. The motion's been denied. Let's get this case moving towards trial. And having that many lawyers on a Zoom call trying to pick one trial date takes, well, hours. The judge was trying to move the dates around so that it would work with the attorneys who all have their own trial calendars, the court who has its own trial calendar, and then trying to accommodate for the jurors and the potential things that might cause jurors to be unavailable for a trial. And they're asking for 5 or 6 weeks of trial time. However, ding, ding, they're also saying no trials on Fridays. Do you remember when Depp v. Heard did no trials on Fridays, how smoothly the case went? Ah, lovely. So they are looking at running trial days Monday through Thursday, which means the court can do all its other work on Friday. We can catch up on our lives on Friday. I'm loving this court schedule. So looking at about 5 to 6 weeks for trial, and they were trying to find when there is a chunk of time to do jury selection before that, which could be 2 weeks. So you're looking at really possibly 8 weeks, including jury selection. And when the court had that much time, and at one point, one of the defense attorneys said, okay, I know we've got all the Christmas break holidays, but why is there just a ski week in February? It's like, I don't know. But there's a ski week in February. So they were trying to find when they could bring in a jury to do trial between the schools having a ski week in February and spring break. So they were like, can we make this trial happen between ski week and spring break? And that's exactly what they decided to do. But we learned some really interesting things at the hearing. This is normally the point where I would pull up media reporting on this, but I haven't seen any from this hearing. So I'm just telling you from the notes that I took at this meeting after court ended in the Karen Read case on Friday. I attended via Zoom the hearing in the Kouri Richins case because we're dealing with West Coast time zones and East Coast time zones, and so it all worked out. Kouri Richins' case gets rescheduled, and they decide that they are going to start jury selection February 10th, and then trial will commence with opening statements and evidence on February 23rd. They expect it to run through March 26th. What's interesting is that we learned about what is still outstanding in this case for the attorneys to do. And as the defense was arguing that this might be a lengthy trial, they indicated that the prosecution witness list has over 100 witnesses on it, and they expect that the prosecution is not going to call all of those witnesses, but that some of those witnesses are going to be lengthy and that there are a number of experts. They're still going to do motions over excluding some of them, but there are a number of experts that may take substantial amounts of time. And if they're running 4-day court weeks, that it looks like they're going to need that amount of time for the trial. And then the defense said, plus we have a defendant who very well may testify, and that will be a lengthy testimony. Excuse me, what? Wait, what? Per the defense attorneys, they are letting the court know that should Kouri Richins choose to testify, which very well may happen, then they will need more time. This would be a multi-day testimony. It could be, if they're running 4 days, it could be a 3-day or 4-day of testimony if she chooses to testify. Remember, she's charged with not just the March homicide, she's also charged with an attempted murder from Valentine's Day from the breakfast sandwich. The breakfast sandwich, not the drink. So there are multiple incidents here that she is charged with. So her testimony about that could take some time, and there are other charges there as well. The defense also indicated in their conversation with the court that this case has a lot of video and audio and defense experts and prosecution experts. But my biggest takeaway, I could hear the record scratch in my brain when she said the defendant may testify, and that may be lengthy testimony. So will the Kouri Richins case go forward as scheduled in February 2026? And when it does, is the court going to allow media? Is the court going to allow streaming? Or are we all going to be watching it on like a 1-day delay, which if we need to do, we're going to do? And if and when it goes to trial, is Kouri Richins going to testify? There are still substantial evidentiary items that are outstanding. There are still motions regarding the admissibility of said walk the dog letter. There are motions regarding admissibility of a notebook journal of Kouri Richins, among conversations about expert testimony. So we will see some court dates, and those normally are not streamed. We get them after the fact, but we will see a few court dates coming up where some of those evidentiary motions go forward, because they're going to need to do their motions in limine. They're going to need to do their experts motions. And so there will be a few more court dates between now and the end of the year, and then everything will pick back up after the new year. So the parties will be back in court on August 1st. It will probably be via Zoom to finish setting dates for all of those motions. We will see more from Kouri Richins before that case goes to trial, hopefully in February 2026. It's been an interesting case to follow. If you haven't followed my coverage on it yet, I will link that down below. It is an interesting case. Every court hearing, there's more information. Every single time they're in court, there's more info. This is the case with Judge M, who a lot of you adore. And of course, you heard Mr. Bloodworth talking about all the law nerds on the internet, referring to the walk the dog letter as the walk the dog letter, because I think Mr. Bloodworth is probably low-key a law nerd. He also is a very snarky writer, so some of those motions have a little bit of sass in them. You know, I love simplifying my routines, and something that can simplify my morning routine is always needed and appreciated, because there is never enough time for a complicated skincare routine. And thanks to today's sponsor, OS1, you can simplify an entire routine into one effective anti-aging product. OneSkin believes the purpose of skincare is not to just improve how you look, but to optimize your skin's biology so that it's more resilient to the aging process. It's like taking your entire skincare routine, backing it with science, and then putting it into one product. So you are on the move faster while still taking care of your skin at all the different levels. So if you are ready to check out skincare that works on all the levels of your skin, it's time to check out OneSkin. In addition to the moisturizer that I love, they also make a great sunscreen for face and for body, because we all need to wear our sunscreen. Founded and led by an all-woman team of skin longevity scientists, OneSkin is refining the aging process with their proprietary OS1 peptide. Get 15% off with code LAWNERD at oneskin.co. That's 15% off at oneskin.co with code LAWNERD. And after your purchase, they'll ask how you heard about them. Be sure to let them know it's the Emily Show. Invest in the health and longevity of your skin with OneSkin. Your future self will thank you. Let's get back to today's episode. And in lively Baldoni Wayfarer, no one's asking for a change of venue, but a substantial amount of the case did get thrown out by the court. We're going to talk about what that means, what it doesn't mean, what's been going on in court, and what causes of action Blake Lively dismissed in her case formally on Friday. And since that's the easiest one, we're going to start with it first, because Blake Lively dismissed with prejudice, meaning you cannot bring it again. It means like, period. You don't get to bring it back. You don't get to revive it. You don't get to do anything with it. It's done, can't bring it again. This was filed on June 13th, 2025, the stipulation of partial dismissal with prejudice. You might have already heard rumblings that Blake Lively was dismissing some of the causes against Baldoni and Wayfarer et al. This has now been formalized. This has been done in court, but before this got done, Lively wanted to ask the court for clarification regarding what information she could bring up about emotional distress. And you'll see why as we get into this stipulation. And yes, these are all the consolidated cases. So when you look at that case title box, you will see all the different titles of all the different causes of action. Lively versus Wayfarer et al., Jennifer Abel versus Jones work, Wayfarer versus Lively et al. It is hereby stipulated and agreed by and between the undersigned attorneys for the parties to the above captioned actions. Plaintiff Blake Lively withdraws and dismisses the 10th cause of action, IIED, intentional infliction of emotional distress, and the 11th cause of action, negligent infliction of emotional distress, asserted in her amended complaint, docket 84, with prejudice. Each party bears their own costs and fees, and without the withdrawal or dismissal of any other claim, counterclaim, or third-party claim asserted herein. So this just takes out the IIED and the NIED. Why would someone do that? Well, if you bring in those causes of action, your medical records, your mental health records, and everything else in your mental health or medical health comes into play, and the parties can require that you have an evaluation. We saw that come into play with the Johnny Depp Amber Heard case when intentional infliction of emotional distress and negligent infliction of emotional distress weren't the causes of action underlying it, but once levels of emotional distress are brought in as either a defense or part of the causes of action, it opens up a lot more information that has to be disclosed in discovery. It does not ever surprise me when parties get rid of these causes of action, because I generally believe that parties, once they learn what that discovery is going to look like, go, wait, shit just got real. They can send me out for an evaluation from someone they've chosen, and we're going to have a battle of the experts over this. No, thanks. So does that surprise me? No. And the clarification that was sought from the court was about bringing in information about general emotional distress and general distress, which will be allowed. But getting into the levels of intentional infliction of emotional distress and negligent infliction of emotional distress opens up a lot for discovery that people generally don't want opened up for discovery. Of course, there is always the choice to not bring them in the first place, but once you start getting into discovery, parties, I think, have a more clear understanding of what that process is going to look like, and sometimes can change their mind, because in a civil case, civil parties sometimes feel very gung-ho about a thing. And then you get all the way into the civil litigation and go, this is not at all what I expected. I don't want to do any of that. So it's not a surprise to me seeing those particular counts withdrawn, because it limits the discovery regarding mental health, medical records, and the rest. And finally, we need to talk about the judge's 132-page order regarding the, well, plethora of anti-SLAPP and motions to dismiss. The parties to the Wayfarer lawsuits brought all of their motions to dismiss and anti-SLAPP motions, and the court ruled on all of them together. So it is motions being brought from Blake Lively, from Ryan Reynolds, and from the publicist, Leslie Sloan, against the Wayfarer parties, as well as the New York Times against the Wayfarer parties. So you have 4 different plaintiffs bringing all of their motions to dismiss. Each of those motions to dismiss have the initial filing, then the opposition, then the reply. So am I surprised that the court's order is 132 pages? No. Does the court have some feelings about the length of the filings in this case? Yes. And he makes it known. At the end of the day, the court's order is that the majority of the Baldoni Wayfarer lawsuits are getting thrown out and cannot be revived. There are areas where things can be refiled before the end of June. We are going to talk about which causes of action can be refiled and which can't. Of course, this can still be appealed if the Baldoni Wayfarer parties choose to appeal it, or the Baldoni Wayfarer parties, because there are still a lot of them, can choose to pursue their case as defendants, because the filings are counterclaims to each other, so they're very interwoven. So everything that the Baldoni Wayfarer parties were talking about is also responsive to the Lively lawsuit. So they can also continue to bring that evidence forward as defendants in the Lively lawsuit instead of as defendants and as plaintiffs. Will they choose to appeal it is going to be a strategic decision, because then you are still dealing with all the Lively cases in court and the appeal on the other side of it. But we could see that go forward. The anti-SLAPP and motion to dismiss are meant to pare down lawsuits at the beginning of litigation before you even get very far into the discovery process. But for a defendant like the New York Times, this dismissal takes the New York Times out of this entirely. It takes Leslie Sloan out of this part entirely. It really just leaves Ryan Reynolds as the opposing party to the Baldoni Wayfarer parties, and then leaves Blake Lively as a plaintiff, but not really as a defendant. So we're going to try to make that as simple as possible. And if you want to do a thorough breakdown of this 132-page dismissal and what some of the arguments and the law was and how the judge chose which law to apply, because there's some choice of law conversations, let me know and we will. Today is an overview of what the court ordered to hopefully make that make sense because, well, we've been covering trial for 8 weeks, so there has not been time to go through everything. But I thought an overview would be helpful, what it means, what it doesn't mean. One of the things that's important to keep in mind about the anti-SLAPP and motion to dismiss process is this is not determining the causes of action on their merits per se. All of the evidence is not in. All of the discovery hasn't happened. This is deciding whether the things complained of in the light most favorable to the party that is not filing. So in this case, the defendants, Baldoni, Wayfarer et al., if the facts taken exactly as Baldoni and Wayfarer say that they are, taken in the light most favorable to them, can it stand as a cause of action? And in some of these causes of actions, the court has said these legally cannot stand, not just because of the way they're filed, but because you cannot sue for this. And then the court explains the reasoning. So let's get into that. We are taking a look at this order from the court from June 9th, 2025 for the consolidated cases of Blake Lively versus Wayfarer et al. And then Wayfarer Studios versus Blake Lively, Ryan Reynolds, Leslie Sloan, Leslie's company Vision PR, and the New York Times. That is the part of the case that this is concerning because that is the counterclaim that we are dealing with. The Lively versus Wayfarer, Baldoni, and the rest of the parties is not the part of the case that we are dealing with today, just the second part. The court gives a very brief background overview before giving the more fulsome overview. And the court says that the Wayfarer party's amended complaint contains allegations regarding a dispute between two well-known Hollywood actors over the making of a Hollywood motion picture. Virtually every fact is hotly contested. Facts. For purposes of this motion, the court accepts as true the well-pleaded allegations of the Wayfarer party's amended complaint. Accordingly, the narrative set out below does not reflect the court's own findings, but simply repeats the account of events stated by the Wayfarer parties in their amended complaint. At this stage of the proceedings, the court has not considered whether the allegations in the amended complaint are true. Footnote 3. The court has said this in numerous filings. This might need to become the new intro to all of the things. But the court says in footnote 3 and reminds everyone that the Second Circuit has cautioned the press to understand court documents, quote, for what they are, including by distinguishing between facts which are found by a court to be true and allegations which are prepared by the parties seeking to advance their own interest in an adversarial process. This court has said frequently and repeatedly that the docket is not to be used for a media circus. It is not the place to lob accusations back and forth that have nothing to do with court. It is not the place to vet salacious details that if you were to say them otherwise or elsewhere, you could get sued for. And the court has really pointed some of those words at the press throughout the court orders in this case, saying, please remember, these are not court findings. These are allegations in an adversarial proceeding prepared by the parties to advance their own interest. Do not take them as fact. So the court has found a way to kind of slip in that caution to the press in the last several filings we've looked at. The court goes on to say that in addition to the allegations in the amended complaint, the court has considered several documents which are deemed to be a part of the amended complaint as a matter of law. The court goes on to say that the documents the court is relying on include the New York Times article that is central to the allegations here. The court talks about why case law does not allow everything attached to a complaint to be considered, and saying that the purpose of that rule is to prevent a complaint from surviving simply because a cleverer plaintiff included certain parts of a key document and left out others. So the court is allowed to take the entire document of the article and consider it even if it's not reposted verbatim in the complaint. Remember, complaints are supposed to be a brief telling of the causes of action. The court says that under this standard, the amended complaint is deemed to include the New York Times article that is subject to the Wayfarer party's defamation claims. And then the court lists out the different docket numbers, including Lively's CRD complaint, a list of 17 protections demanded by Lively to return to production in November 2023, emails between the New York Times and the Wayfarer parties. Each of these documents is extensively quoted and discussed in the amended complaint. So what the court's considering is the New York Times article, Lively's CRD complaint, the accompanying video made about the New York Times article, the production demands from Lively that were attached to her complaint, and I think his as well, and the emails between the New York Times and the Wayfarer parties that the Wayfarer parties quoted in their complaint and attached. The court goes on to say, in determining whether the Wayfarer parties have stated a claim for relief, the court does not consider Exhibit A to the Wayfarer parties' amended complaint. Remember, Exhibit A was that timeline. It was extensive. It had a lot of information in it. The court is saying that they are not considering it. The court says under the federal rules of civil procedure, a defendant is entitled to know the allegations against it and to have those allegations framed in separate paragraphs with sufficient clarity to allow the defendant to frame a responsive pleading. The court says that the body of the Wayfarer party's amended complaint is 224 pages long. I said that the federal court wasn't going to like that the docket was 224 pages long, and the court is like, look, it's a complaint. It should not be 224 pages long. The court then says docket number 50, Exhibit A, is a quote-unquote timeline providing a quote-unquote summarized account of the sequence of key events, which is an additional 168 pages long. It is significantly, but not entirely repetitive of the amended complaint, and it does not set out its claims in numbered paragraphs as required by Federal Rule of Civil Procedure 10. The document is not a written instrument that evidences legal rights or duties, or otherwise form the basis for the Wayfarer party's claims, but it is simply an additional narrative summary. If such a document could be deemed part of a complaint, then Rule 8A's requirement of a short and plain statement of a claim for which relief could be granted would be eviscerated. If the Wayfarer parties wanted any factual statements in the timeline to be considered, they should have alleged them in the amended complaint, footnote 6. The court is not happy at all with how lengthy and factually specific and narrative the pleadings were. And the court is like, if you wanted me to consider it, then you should have put it into the complaint. But a complaint under Rule 8A is supposed to be a short and plain statement of a claim. And this is not that. The court's like, there's too much tea. Stop spilling it. Footnote 6. At this time, the court will not grant the motions to strike Exhibit A from the docket because the parties did ask to have that exhibit stricken from the docket. And the last time I covered this case, the court did strike items from the docket that the court found were just fodder for newspaper sensationalism or media sensationalism. But the court says at this time, the court will not grant the motions to strike Exhibit A from the docket, meaning take them out of the public view. The court says Federal Rule of Civil Procedure 12F authorizes courts to strike any redundant, immaterial, impertinent, or scandalous matter from a pleading. The court says Exhibit A is largely redundant of the amended complaint, and given that it must be discarded, it is immaterial to the court's decision on the motion to dismiss. But the fact that material is irrelevant or must be disregarded generally does not justify striking it from the docket unless permitting the allegations to stand would result in prejudice to the movement. And the court's like, look, this is duplicative. It has been said. I'm not considering it, but I'm also not striking it because, well, it's already been said. Here's the court's brief procedural history of this case after they did an extensive factual summary. The factual summary is adopting the facts as they were pled by the Baldoni Wayfarer parties and taking them in the light most favorable to those parties because it is a motion to dismiss with an anti-SLAPP component, which is strategic litigation against public participation. We'll get into anti-SLAPP another day, or you can watch my other content about it because these can get discussed synonymously for our purposes today. On December 31st, 2024, Lively filed a complaint against the Wayfarer parties in this court, bringing claims for sexual harassment, retaliation, breach of contract, IIED, and NIED. The Wayfarer parties then filed their original complaint January 16th, 2025. The New York Times was not named in that complaint. Side note, they were sued in California first. On January 30th, the court ordered the parties to show cause by January 30th. Yes, that's not a typo. The court was like, tell me today why I should not consolidate these matters. And then the court consolidated the matters, meaning put them all in one case. On January 31st, the Wayfarer parties filed an amended complaint naming the New York Times as a defendant. So the California case got dropped. They brought the New York Times into the case in federal court in New York. On February 3rd, the court held an initial pretrial conference and entered a case management plan and scheduling order. The case management plan and scheduling order provided, among other things, that any motion to amend or join parties be filed no later than April 18th, 2025. On February 20th, Sloan and Vision PR filed a motion to dismiss, accompanied by a memorandum of law. On March 6th, the Wayfarer parties filed the opposition to that motion to dismiss. On March 13th, Sloan and Vision PR filed the reply. On March 17th, Sloan and Vision PR moved to stay discovery pending the decision on that motion to dismiss. The motion was denied on March 21st. This ruling from June 9th is the ruling on that motion. On February 28th, the New York Times filed a motion to dismiss, accompanied by their memorandum of law with 12 exhibits. The Times also filed a move for leave to file hard copy materials with the court on a flash drive, which was granted. The same day, the Times moved for a stay of discovery pending the motion to dismiss. March 4th, the motion was granted and discovery was stayed as to the New York Times, meaning the Baldoni parties thought that they would be able to start discovery with the New York Times. And the court said, no, we are not starting discovery with the New York Times. We're waiting until we get to the end of the motion to dismiss. On March 14th, the Wayfarer parties filed their opposition to the motion to dismiss. And then the Times filed a reply on March 21st. On March 18th, Reynolds filed the motion to dismiss. On April 1st, the Wayfarer parties filed the opposition. On April 9th, Reynolds filed the reply memorandum of law. On March 20th, Lively filed a motion to dismiss, which surprised me that she wasn't one of the first, but they had a whole bunch of other litigation going on. But it did surprise me that the Lively motion to dismiss wasn't one of the first ones. Still within the time period, but I found it surprising. But there was lots of litigation going on. On March 20th, Lively filed a motion to dismiss, accompanied by a memorandum of law. On April 3rd, the Wayfarer parties filed a memorandum of law in opposition. On April 10th, Lively filed the reply. On April 15th, the Wayfarer parties filed a letter notifying the court that the parties would not move to amend their pleading by the April 18th deadline set out in the case management order. They stated that if the court were to grant one or more of the motions to any extent, the parties will move for leave to amend pursuant to Federal Rule of Civil Procedure 15A2 and seek a commensurate modification of the scheduling order for good cause. So from there, those are all the motions that we are dealing with. The New York Times, Ryan Reynolds, Blake Lively, Leslie Sloan, and her company. The court goes on and sets forth the legal standard that to survive a motion to dismiss pursuant to 12b-6, the complaint must include sufficient factual matter accepted as true to state a claim upon which relief can be granted. The court cited case law that says to state a claim to relief that is plausible on its face. However, in my mind, 12b-6 is to state a claim upon which relief can be granted. That's where the default is. The complaint must offer more than, quote, labels and conclusions, a formulaic recitation of the elements, or naked assertions devoid of further factual enhancement to survive a motion to dismiss. And then the court gets into their discussion. This is a summary of what the court decides. This is a 132-page order, so we're not going to get into all of it, but I think the summary is helpful. The amended complaint focuses broadly on two types of claims, the court says. First, the Wayfarer parties claim that Lively, assisted by Reynolds and Sloan, stole the film from Baldoni and Wayfarer, threatening to refuse to promote the film and attack Baldoni and Wayfarer in the press if the Wayfarer parties did not agree to grant her, rather than Wayfarer, control over and credit for the film. The Wayfarer parties seek damages for this conduct based on the legal theory that Lively, Reynolds, and Sloan committed civil extortion. Second, the Wayfarer parties claim that Lively, Sloan, Reynolds, and the New York Times spread a false narrative that Baldoni committed sexual misconduct towards Lively, and the Wayfarer parties then engaged in a smear campaign to ruin her reputation. The Wayfarer parties claim that by doing so, Lively, Reynolds, Sloan, and the New York Times committed the torts of defamation and false light. Although these two types of claims are the focus of the amended complaint, the Wayfarer parties also bring claims for breach of contract, tortious interference with contract or prospective economic advantage, and promissory fraud. Emily, what do all those things mean? I will link it down below. We went through all of them, but torts are the civil claims versus criminal. Emily, why is it called a tort? I'm sure I knew at one point. I have completely forgotten by now. We're not talking about desserts. So tortious interference is a civil interference with contract. The court goes on to say that the Wayfarer parties cannot recover for Lively's alleged actions to steal creative control of the film from the Baldoni and Wayfarer parties. Regardless of the propriety of these actions, they do not constitute civil extortion under California law. Emily, why are we talking about California law? Well, because all of these pleadings were made in New York using California law. California is where the contracts were entered into. So you can bring a claim in New York under California law, and then the court has to evaluate the California law in the courts in New York. So the courts in New York evaluated the California law and said that the actions alleged do not constitute civil extortion under California law. The court says that California courts have recognized a claim for civil extortion, not criminal, in situations where a plaintiff gives a defendant money or property under threat and seeks to have it returned. However, the Wayfarer parties, the court says, have not adequately alleged that Lively's threats were wrongful extortion rather than legally permissible hard bargaining or renegotiation of working conditions. Additionally, the Wayfarer parties have not shown that some of Lively's alleged extortionate acts damaged them. So, the court is saying, as a matter of law, the facts as they're alleged, if they take everything that the Baldoni parties say is true, it is still not going to rise to the level of a civil extortion claim in California. So the court has said this claim, as a matter of law, cannot be found. There has to be damage. You have not shown that there's damage, probably because the movie was released and made money. So there can't be a claim for civil extortion. The court goes on to say, the Wayfarer parties cannot recover on their defamation claims. The Wayfarer parties have not alleged that Lively is responsible for any statements other than the statements in her CRD complaint, which are privileged. The Wayfarer parties have alleged that Reynolds and Sloan made additional statements accusing Baldoni of sexual misconduct, and that the Times made additional statements accusing the Wayfarer parties of engaging in a smear campaign. But the Wayfarer parties have not alleged that Reynolds, Sloan, or the Times would have seriously doubted the statements were true based on the information available to them, as is required for them to be liable for defamation under applicable law. We have talked about defamation of public figures. There has to be a malice element. Malice is not based on vibes. It is a legal term of art. It does not mean ill will. It does not mean meanness. It does not mean anger. In the legal term, malice, as used as a term of art in defamation of a public figure, means that you have to know that it's not true and proceed anyway. So when the court is saying that the Wayfarer parties have not alleged that Reynolds, Sloan, or the Times would have doubted the statements were true, the court is getting at that malice element of public figure defamation, and that the malice element would have to exist and you have to be able to plead it. The court goes on to say, the Wayfarer party's additional claims also fail. Accordingly, the amended complaint must be dismissed in its entirety. However, the Wayfarer parties have leave to amend their claims for breach of implied covenant and tortious interference with contract. So the court is allowing 2 of the claims to move forward, but not the rest. So let's take a look at what the court says in dismissing those. In a little bit of an asterisk, interesting footnote for me, all of the parties did argue that the complaint had impermissible pleading or improper joinder. I had brought that up because I was curious to see how the parties would navigate it, because a lot of the causes of action were Wayfarer parties, but there are numerous parties. And then to the Lively parties, which included the New York Times, Blake Lively, Sloan, and Ryan Reynolds. So sometimes it was hard to tell which defendant was suing which plaintiff. And I was interested what the court would do with that. And the court said, I'm not considering it because we have other shit to talk about. And I was like, damn it. I really was curious how they were going to get around the joinder issue, but that's more of a form over substance, and the court went directly to the substance. But it was pled in all of those motions to dismiss because it is one of those things that when you look at this case, you're like, but how does the defamation cause go to all plaintiffs and all defendants? That's just nerdy me closing the loop on the joinder question that I also had. When the court moves on to talk about the defamation claim, this is how the court breaks down the issues of privilege with regard to the defamation claim. The court says the factual allegations pleaded in the amended complaint do not state a claim. This is going to defamation. The court says they support at most the plausible inference that Lively or someone acting on her behalf provided the Times with a copy of the CRD complaint and related text messages before the complaint was filed. Yeah, I think that is a very plausible inference. The court goes on to say, while the article was published on December 21st, 2024, the day after Lively filed her complaint, the Times asked the Wayfarer parties to comment on the article at 9:46 p.m., reporting on the CRD complaint on December 20th, 2024, the same day it was filed. Yes, they had it very quickly. The court says there is a powerful inference that the Times had access to the CRD complaint well before that date. I don't disagree. The article and the CRD complaint are both purportedly based on, quote, thousands of pages of text messages and emails that Lively obtained through subpoena, which the article states, quote, were reviewed by the New York Times. The court says URLs for the images and PDFs and videos associated with the article contain the dates of December 12th, December 10th, and December 16th. And then it cites where the Baldoni pleadings say that. They say that the article draws heavily from Lively's CRD complaint. It would have taken time to review the complaint and its attachments. In addition, source code for portions of the article contains a date of October 31st, 2024. And that's coming from Baldoni's complaint, and the court cites that. The court says, and because the Times had access to the CRD complaint before it was filed, and while it was still confidential, there is also a powerful inference that it was provided by Lively or someone on her team. Right, where else is it going to come from? They said that Lively obviously had access to the CRD complaint before it was filed. It only makes sense that the CRD complaint was given to the Times by Lively or someone acting on her behalf. Agreed. The court goes on to say, if the complaint was provided to the Times, it is highly likely that Lively played a responsible part. The court goes on to say that the act of providing the CRD complaint to the Times is not sufficient to constitute defamation because the complaint is protected by the fair reporting privilege. The CRD complaint is a filing in a, quote, quasi-judicial proceeding, and they cite case law that says California courts have constituted the phrase judicial proceeding broadly to include the filing of the complaint. They say that the fair report privilege applies to Lively providing the complaint to the Times because it's a communication to a public journal of statements said in the course of a public proceeding. So the court is saying that this is a public proceeding, a judicial proceeding, plus there is a reporting privilege. And with those two things, the privilege covers Lively for anything that was in the CRD complaint, and the court says that they can't prove Lively said anything other than what was in the CRD complaint, and that the New York Times is covered, by the reporting privilege. The court goes on to say that the Wayfarer party's main response is that the privilege does not apply because at the time Lively provided the CRD complaint to the Times, it had not yet been filed in an official proceeding. The court says, however, under California law, a party need not wait until a legal document is formally filed before providing it to members of the press. The fair report privilege extends to advance communication to a public journal of a complaint so long as the party intends in good faith to file it in a public official proceeding. We talked about this a bit in the Ryan Kavanaugh, Ethan Klein defamation case because Ethan Klein was talking about an article that included a civil complaint that had been filed, but not officially filed. So the publication got it, but it was never officially filed on the docket. And the publication reported on it, and then he reported on it. And then we talked about that quite a lot in the scope of that lawsuit about the gap in time when the media might have access to a pleading that is not formally filed and part of the docket yet. And it does not surprise me to see the New York court saying, right, and California really gives space for that, saying that if a legal filing is not filed yet, but there is good faith that it intends to be filed, then it's covered. The natural question is, does that allow the courts to be used for people to hurl accusations at one another and be shielded from defamation suits? Well, you have to say that you have a good faith belief in filing it, and lawyers have to sign a lawsuit saying that, yes, this is substantially true, but also what is to stop someone from saying, yeah, I believe that that's true. My client told me it was true. It is a growing issue, and it's something that I think the court in this order is cautioning against in the footnotes, saying the media needs to remember that filings and allegations are just that. I think the difficulty comes in because people want answers quickly and legal process takes so long. The second the headlines hit, the second an allegation is made, people want to know everything that's happened, and legal process takes so much longer than that. And it can be incredibly frustrating to wait for legal process to play out. But we see the court's caution here saying, look, this is how the privilege works. But remember, what is said is allegations. And if you were all watching along with me as the court was reading the jury instructions, one of the jury instructions in Massachusetts literally says, slow down, take a minute, evaluate all of the information, literally in the jury instructions. And it is a slow process. I know how frustrating that can be because people want answers. But I do think when it comes to things in court, it is very important to remember that we need to slow down and remember that the process is long. The way things seem at the beginning of the case and the way things may seem at the end of the case might not be the same. If you watched the Gwyneth Paltrow ski collision trial with me, you probably saw that play out. For a lot of people, they saw that play out in the Johnny Depp Amber Heard case where you see it change during trial. You're like, wait a second. So you can see it shift. Legal process is slow. I just wonder if there was more patience for the process, if it wouldn't be so damaging to those that had allegations made against them before they play out. But I also completely understand that when people step forward and make their voices heard in lawsuits, people want to believe that no one's going to game the system. But I think the only way we know that is letting cases play out as they naturally occur. Because otherwise, what we are going to see is everybody rushing to court to make those statements that you can't really protect against, because once they're made in court, they're privileged. It is a frustrating push-pull of, well, can anyone say anything? It shouldn't be that way. And I wonder if we're going to see courts take stronger action going forward with lawsuits that are harassing, with lawsuits that are unfounded. But a lawsuit getting thrown out or settled doesn't necessarily mean that either. But there is a push-pull within the legal system about where the line is and how far is too far on allegations that aren't supported down the road and what happens from that. because so often we see the headlines when a thing first happens and there's not any follow-up to it. So I absolutely understand but wait a second, if it's all protected, then what do you do? Right, you have to let it play out in court. And that is slow. The court goes on to say, after I soliloquied, that fair report privilege only applied to reports in a public journal, not communications to the journal. But the court goes on to say that the California legislature extended the privilege to protect individuals who communicate litigation statements to the press. So California expanded that, which does not surprise me. California also has a very vigorous anti-SLAPP that throws cases out before any discovery starts. So it does not surprise me that the privilege to speak to media and to communicate litigation statements is expanded in California, and these causes of action were filed under California law. The court goes on to say that here there's no basis to infer anything other than that the litigation was actually contemplated seriously and in good faith. And the court supports that proposition by saying, in the first place, Lively commenced litigation. She filed the CRD complaint within months of the events described in the complaint, and not long after it was plausibly given to the Times. 11 days after she filed the CRD complaint, Lively filed in this court, making the same allegations that she made before in the CRD complaint. The Wayfarer parties assert that the fact that Lively eschewed the administrative process and filed suit in federal court instead demonstrates that she did not file her CRD claim in good faith, but the conclusion does not follow from the premise. And the court says it's required under California law that before suing for any violation of the California Fair Employment and Housing Act, a plaintiff must file timely and sufficient administrative complaint with the CRD and then get that right to sue notice, which they say she did, which we know that she did because it was part of the process for filing the civil suit. As the court addresses the Reynolds causes of actions, the court says that the Wayfarer parties argue that Reynolds defamed Baldoni by telling a WME executive at a premiere of his movie Deadpool and Wolverine that Baldoni was a quote-unquote sexual predator, and using the same term in a phone call to Baldoni's agent. The term quote-unquote sexual predator is broader than the term sexual assault, and they bring that up because the court was previously talking about statements made by Leslie Sloan, and says, but in this context could reasonably be understood to imply that Baldoni engaged in sexual misconduct towards Lively. The court goes on to say, however, as with Sloan, the PR agent, Reynolds was not present for any events during filming, and the amended complaint does not provide any reason he would have doubted Lively's version of the events. The court goes on to say, in fact, several allegations in the complaint support that Reynolds believed that Baldoni engaged in sexual misconduct towards Lively. The court says during pre-production, Reynolds screamed at Baldoni after finding out that Baldoni had asked his trainer about Lively's weight. And the court also cites that Reynolds then later yelled at Baldoni and demanded he apologize for actions that had never happened in connection with the return to production demands, becoming further enraged when Baldoni refused to apologize. Given that the return to work production demands concerned Baldoni's alleged inappropriate behavior towards Lively, the obvious inference is that Reynolds was yelling at Baldoni about this alleged behavior. The court goes on in footnote 50 to say that Baldoni allegedly denied this behavior, and then gets back into the fact that the facts tend to suggest that Reynolds believed that Baldoni had inappropriately commented on Lively's body and had engaged in inappropriate or quote-unquote predatory actions toward Lively during filming. The court says that the Wayfarer parties argue that actual malice can be inferred from Reynolds' quote deep disdain for Baldoni. That's a vibes argument. And the fact that he was trying to convince WME to drop Baldoni when he made the quote-unquote sexual predator statements. The court goes on to say, as noted above, actual malice refers to the knowledge of falsity or recklessness, right, not vibes, with respect to truth rather than a motive to harm, and motive alone is insufficient to show actual malice. The court goes on to say Reynolds may have disliked Baldoni, as the amended complaint suggests, but that does not mean he knew Baldoni had not engaged in misconduct or was reckless with respect to whether he had engaged in misconduct. The facts alleged in the amended complaint, in fact, suggest an inference that Reynolds disliked Baldoni because he believed he did engage in misconduct towards Reynolds' wife, footnote 51. Footnote 51, Nice Pool. The Wayfarer parties also allege that Baldoni created a character named Nice Pool. No, that's not what Baldoni said. Your Honor, you've gotten lost in the sauce. I know it was like 400 pages, but it's not that Baldoni created a character named Nicepool. It's that Reynolds created a character named Nicepool to mock Baldoni. Judge, no. The court goes on to say Nicepool made a reference to an intimacy coordinator and commented inappropriately on a female character's attractive body after childbirth and excused his remark by claiming he identified as a feminist as a transparent and mocking portrayal of Reynolds' warped perception of Baldoni. The court says this allegation does not support the claim that Reynolds disliked Baldoni for reasons independent of his belief that Baldoni engaged in misconduct as opposed to for that very reason. To the extent that the amended complaint suggests that Reynolds' portrayal of Nicepool could be defamatory, the portrayal of Baldoni as a fake feminist who makes inappropriate comments is clearly subjective and unverifiable opinion. Nicepool gets a footnote in the court's order, but the court is explaining that actual malice in the field of defamation goes beyond vibes. It has a legal term of art. The court says that no actual malice exists when a defendant seeks to harm plaintiff by spreading facts the defendant genuinely and not recklessly believes are true. In talking about the breach of implied covenant of good faith cause of action against Lively, the court says that the Wayfarer parties allege that Lively breached the implied covenant of good faith and fair dealing in the contract by which Lively agreed to perform as an actor in the film It Ends With Us by making threats, seizing creative control, and depriving the Wayfarer parties of the opportunity to produce, edit, and market the film as contemplated by the contract. The court notes that California does recognize the implied covenant of good faith with every contract, and the court goes on to say that the covenant of good faith and fair dealing cannot impose substantive duties or limitations on the contracting parties beyond those incorporated in the specific terms of the agreement. The court goes on to say that the Wayfarer parties' breach of implied covenant allegations are conclusory. The Wayfarer parties do not plead the terms of the relevant contract, which of the Wayfarer parties it was with, or when it was made. The amended complaint contains vague references to contract negotiations and entitlements, but it also includes several times that Lively did not sign her employment contract for the film. The court goes on to say the Wayfarer parties do not allege any particular contractual provision that gave any particular Wayfarer party the opportunity to produce, edit, and market the film, or that prohibited Lively from involvement in the production, editing, or marketing of the film. Therefore, they do not identify any contractual provision, the existence of which Lively frustrated. So the court is saying, look, you said that there was a contract, you said that there were terms, you said that the terms were violated, but you didn't tell us what the contract was. So we need to know that. The court concludes with the breach of implied covenant claim is dismissed. But it is one of the claims the court is allowing to be modified, because you can see how the parties might be able to modify their pleading to bring that contract more specifically to light. That may exist. The last point before we get to the very end of what is now an extensive episode talking about this. Emily, you said summary. It's still a summary because it's so long. And, you know, there's no court today. So you're like, what are we going to do anyway? Watch a fan? No, we're going to hear about this. The court talking about the tortious interference with contractual relations or prospective economic advantage says that the Wayfarer parties allege that the Lively and Reynolds parties intentionally interfered with a contract between the Wayfarer parties and WME, their agency, by making threats to induce WME to quote unquote drop Baldoni. They also allege in the alternative that Lively and Reynolds intentionally interfered with prospective economic relationship between the Wayfarer parties and WME, and as a further alternative, that Lively and Reynolds negligently interfered with the relationship between the Wayfarer parties and WME. The court goes on to cite the California law about tortious interference with contractual relations. Look, we've talked about this a couple different cases, but it's knowing someone has a contract and then interfering with that contract as a very simplified version, and then there has to be damage from that. The court says that the Wayfarer parties failed to allege facts regarding their relationship with WME to support any of these torts. It said that there was a relationship with WME, but it doesn't say what the relationship was beyond that it was their agency, what their contract was, what they had in the works, what they were negotiating. And I can understand that some of that might be proprietary information, what Wayfarer, a production studio, or Baldoni, an actor, was negotiating with his agent or the company's agent. So I can understand that some of that might be proprietary, but if those things were lost and then there is damage, that should be able to be added into an amended complaint, which is why I think the court is allowing this cause of action to be amended. The court says the amended complaint alleges that WME is Baldoni's agency, that Lively, Reynolds, Wayfarer, and Baldoni were represented by the same talent agency, and that Reynolds told WME that the agency was working with a quote-unquote sexual predator and demanded that the agent, quote, drop Baldoni. However, the Wayfarer parties do not allege that they had a contract with WME, the breach of which Reynolds knowingly induced, or any economic benefit that would have been realized from a prospective relationship with WME with which Reynolds could have interfered. They also failed to allege that WME was influenced by Reynolds' statements in any way, aside from conclusory statements that WME, quote, ceased performing and the relationship was disrupted, or that the Wayfarer parties were harmed. The court says this is fatal to all three claims because there is no claim in the absence of facts showing that a relevant economic relationship existed. And again, the facts of that relationship should be able to be pled. The court goes on to say, regarding the claims of interference with prospective economic advantage, because the Wayfarer parties do not allege that Reynolds' statements were defamatory, they do not allege that they were independently wrongful. It says, finally, the Wayfarer parties admittedly do not allege a duty of care to support a negligence claim. As we get to leave to amend, we will see what the court ultimately concludes with the causes of action. The court says that the Wayfarer parties seek leave to amend their complaint to cure any pleading defects. The court goes on to say the Wayfarer parties' proposed amendments would 1. Cure impermissible group pleading, 2. Include additional facts relevant to choice of law, 3. Address the fair reporting privilege and actual malice as applicable to the New York Times, 4. More fully incorporate the allegations in Exhibit A, 5. Amend allegations relevant to the civil extortion claim, 6. Amend the false light claim, 7. Add additional allegations of conspiracy to defame, and 8. Specify that Lively's contract requires that her right to consult and approve on the film be exercised in a reasonable manner and not frustrate Wayfarer's production, and 9. Adequately allege Baldoni's contract with WME in support of the tortious interference of contract claim. The court says defendants oppose the leave to amend on grounds of futility and undue delay. And the court concludes, quote, the court will not grant leave to amend the majority of the Wayfarer parties' claims because amendment would be futile. The dismissal of the claims does not rest on technical pleading defects, and that the Wayfarer parties have not made, quote, a showing that the complaint's defects can be cured. The Wayfarer parties do not identify any particular factual allegations that could be added to support the defamation or civil extortion claims, nor is it plausible that any allegations not yet mentioned would change the basic substance of Lively's threats, the conclusion that the CRD complaint was privileged, the conclusion that relevant statements were made without actual malice. In addition to their 224-page amended complaint, the Wayfarer parties have already submitted to this court an additional 168-page exhibit with additional details relevant to their claims. Although the exhibit is not properly considered for purposes of the motion to dismiss, the allegations within it still would not allow the Wayfarer parties to state a claim. The exhibit contains additional details on Lively's threats, but if anything, these details cut against a finding of extortion. For example, the exhibit details that for some time Sony and Wayfarer in fact resisted Lively's request, stating, quote, this is a Wayfarer movie. Wayfarer has final cut and runs the process. It then states that Lively did not sign her acting agreement so that she could continue to leverage her promotional participation as a bargaining tool, implying that Lively may not have had a contractual obligation towards Wayfarer to promote the film. Incorporating these facts would not aid the Wayfarer parties in alleging that Lively's threats were legally wrongful and could not be resisted. If, in fact, Lively did not owe Wayfarer an obligation to promote the film, her demands regarding what she would need in order to comply with the request that she was engaging in promotion would not have been wrongful. They would constitute hard bargaining. Similarly, although Exhibit A contains a number of messages between the Wayfarer parties not included in the amended complaint, these messages are consistent with those included in the amended complaint and would not show that the New York Times acted with actual malice. Given that the Wayfarer parties have already provided an extensive record of facts that purportedly portrays their claim in the best light possible, the promise that more unspecified facts will now change the central aspects of their core claims suggests a dilatory motive to extend the litigation rather than a legitimate belief that amendment will alter the court's determination. The court is not pleased. The court goes on to say, however, the court will grant leave to amend the claims for tortious interference with contract and breach of implied contract. The Wayfarer parties failed to plead the specific details of any contract between Baldoni and WME, but suggest in their briefing that this defect is easily curable, and that they will plead an oral or implied contract of which Reynolds was aware. So it sounds like WME does not have a written contract with Baldoni, but that there was a agreement that Reynolds was aware. And it sounds like he was aware, because why would Reynolds tell anyone at WME stop working with Baldoni if he didn't think they worked with Baldoni? So if that statement is true, then it would seem that he was aware of any such agreement with the agent or the agency itself and Baldoni. But also, it seems that Wayfarer is not a part of that, just Baldoni. The court goes on to say, given the allegations that Reynolds told WME to quote unquote drop Baldoni, it cannot be said that repleading this claim on such terms would be futile. Similarly, the Wayfarer parties assert that they are able to allege the details of Lively's contract with Wayfarer, including that her right to consult the film be exercised in a reasonable manner. Without seeing the contract, the court cannot say that amending the breach of implied covenant claim would be futile. So the court is allowing amendment by the end of June with Baldoni and Wayfarer versus Lively on the implied covenant of good faith claim. And then it seems just Baldoni versus Ryan Reynolds on the tortious interference of contract claim with regard to WME. So of all of the claims that were brought, those two, one between Baldoni, Wayfarer, and Lively, and one between Baldoni and Reynolds, are the two that they will be allowed to amend. They have not amended yet. They have time to do that and bring forth those contractual terms. Of course, this can also be appealed, and we will see if they choose to do that. The court also talks about the motions for fees. All the parties made a motion for fees and costs under New York's anti-SLAPP laws and New York's civil rights laws, and not just attorney's fees, but also damages and punitive damages under the California Code as to Lively only. The court says that at this time, the court is not granting any of those fees, and those need to be briefed. So this is not done because all the argument over the fees is going to happen. Remember, in those anti-SLAPP litigations, they often include provisions that if you win the anti-SLAPP motion, the other party pays you attorney's fees, but that all starts a separate briefing process, and that's what the court said here. We are not doing attorney's fees now. We can have full separate briefing on attorney's fees. So when you win an anti-SLAPP motion, yes, you can have attorney's fees. And yes, in New York and California, anti-SLAPP motions come before discovery is done. We talked about this quite a lot in the Depp Heard case because we talked about moving the case from California to Virginia allowed the case to get through discovery. Because if that case had been heard on anti-SLAPP in California, none of the discovery would have happened yet. How much came up in that trial that came out of discovery? Most of it. Most of that case came up during discovery. So if that case had gotten stopped before discovery happened, then it likely would not have gone to trial. It likely would have gotten thrown out at the anti-SLAPP stage. Different states have different anti-SLAPP laws. California's anti-SLAPP laws can cut cases out before discovery even begins. And this case, though filed in New York, is using some of those California laws. So we are seeing that choice of law come into play here. We didn't get in depth on it because it is such a long order in the first place. But the choice of law is a huge part of the practice of law because knowing which law is going to be more beneficial to your case, depending on where you file, where you write a contract, where you have a business, matters quite a lot. So at the end of the day, the court dismissed with prejudice, not to be refiled, the majority of the Baldoni Wayfarer suit against Lively, Reynolds, Sloan, and the New York Times. In fact, as to Sloan and her company and the New York Times, they are entirely out of it as to these parties. Reynolds and Lively may still be in with those two causes that can be amended. Now, of course, there's going to be ongoing litigation about attorney's fees. We will see what happens there. If this gets appealed, then we will see what the appellate court chooses to do. But for now, the majority of that lawsuit has been dismissed by the court and cannot be refiled. It will pare down the litigation some, but everything in that complaint is essentially an answer to Lively's complaint. So those causes of action are just going to become the answer and really the defense to Lively's cause of action. So they are still going to continue to play out in court because the other litigations are still ongoing. So let me know if you want to go through that even more thoroughly, because there's a lot more law in there, a lot more explanation about the different causes of action. And if you are interested, we will go through all of it, because choice of law is deeply nerdy, but I am always fascinated when you see the interplay of different laws in different jurisdictions and how those different issues of privilege, reporting privilege, and litigation privilege play out when it comes to defamation claims. Let me know if you're interested. Don't forget to get the Law Nerd app. We are still in Verdict Watch, and I will see you in the next one. Thank you for being here. Thank you for being a Law Nerd. You're the best. And I hope you enjoy the supersized, virtually 2-part Emily show this week, because there will not be a new Emily show next week because I will be traveling. So hopefully this covers it for the next 2 weeks and everything will just be slow and everything will be calm. No, that's never going to happen. All right. I will see you in the next one. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.